Day 147 of the Young Thug YSL RICO trial was tedious. Investigator Sprinkle is back up on the stand and talks about more things we've heard a million times. Later on, Judge Whittaker revokes 5 years from Mounk Tounk's probation and puts him in custody. Yeah, the ending of this video is a rough watch, boys. I feel bad for Mounk Tounk. I was terrified this was going to happen, and it ended up happening. So, looks like he's probably going to have to serve around 3 years, if I were to guess, on good behavior and everything in there. So, hit subscribe, join channel membership. Let's go, boys. First look at Thug on day 147.
Good morning, Your Honor.
Morning.
I could do that, or we can just argue it now. I think the state's cases and facts are not lined up with the reality of what happened in our case, and I don't believe it. I think it's specious. So I don't think, if you want, I can respond in writing, but I don't believe that the state's motion in any way should affect our time in this case, and we should move forward. And that's my position. I put it in writing.
So the motion he's talking about is state's motion to reconsider oral orders striking witnesses' testimony and related exhibits. They cite a few cases and rules where they think it, the judge should reconsider her ruling. I ain't reading all that because my mouth is still hurting from biting my cheek. Might have to go to the fucking doctor here pretty soon. Cite Schardt versus Rogers, State versus Orr at the top. Rule 611 does not authorize an order excluding evidence, thus would not justify the order at issue here.
The state is wrong.
Okay, I don't want to argue it right now. I want a written response. All right.
So we come back an hour and a half later. I don't know what's going on, dude.
In that context, he just came back from a prelim. So to someone that's not a lawyer that practices in Fulton County, you would get the impression that Woody and D and the other D let everything out in court. I think it's pretty clear he's referring to the detectives the detective that testified at the prelim. Okay. So we're going to work on a stipulation that lets the jury know that a detective testified at a prelim on that date to add context to that statement, if it makes sense. Because otherwise, I would have a 403 misleading objection. Okay.
All right, so Mr. Abati right here is going to be questioning Sprinkle. They look pretty similar. So yeah, here we go.
Some jail calls as it related to the case involving the murder of Donovan Thomas. Do you remember that?
I do.
Okay, so I want to kind of start there and follow up a little bit about how you do that. Okay. So could you tell me a little bit about the system that you utilize or are able to use in order to...
We've heard him talk about jail calls and how he goes through them in the system. Unreal they're starting it like this.
Did you also pull calls that relates to Mr. Kendrick?
I did.
And can you tell the jurors, did you utilize the same procedures you kind of just described to the jury when talking about the calls that you pulled and reviewed for Mr. Jackson?
I did.
His brother called him at 6:27 p.m.
Objection. Did the handset related to Mr. Copeland's brother call the handset related to Kenneth Copeland?
Yes.
Okay. Did Mr. Copeland's handset or telephone that's associated with him, did he pick up?
Well, it appears that he did. It was a 24-second conversation.
Okay. And do you recall during the interview that Mr. Copeland did on June 10th of 2015 what he described as it related to his activity in the early evening?
He said that he was at his house, been taking a midday nap.
Yes.
I'm going to object at this point. I believe this is cumulative to the information elicited from Mr. Burney.
My response would be Mr. Burney, or Agent Burney, as he testified. He didn't review any sort of statements, so he was not in a position to talk about the consistency of the statement as it relates to the records, which was the necessity. The whole reason we needed to call Mr. Sprinkle back was due to that unfortunate scheduling issue.
All right, I'm going
to... And Your Honor, I think those would be juror issues.
Mr. Copeland was impeached on multiple occasions by multiple parties before this court and this jury, and this is prior consistent statements and activity as it relates to his impeachment.
I'm going to overrule the objection.
First hour of this, literally pointless about phone calls.
Shortly after he called the handset related to or associated with.
Your Honor, I think that this is out of
Mr. Sprinkle's expertise, and these are questions for Agent Burney, which have been asked.
Okay, so if that may be true, if I'm understanding what it is that Mr. Sprinkle's testifying to.
I can lay a foundation.
Okay.
Mr. Sprinkle, do you utilize or do you review call detail records on a regular basis as a part of your job responsibilities and duties with the District Attorney's Office?
Yes.
And can you tell the jurors how often do you do that?
Multiple times a week. I don't want to go so far as to say every day. I'm sure there's days that I haven't, but it's thousands upon thousands of times, thousands of sets of phone record, at least over 1,500 sets of phone records, and that's a conservative estimate.
60% of you aren't subscribed. Come on, hit the subscribe bell.
Did you utilize cell site location information to map different calls for Kenneth Copeland after you listened to his recorded statement on June 10th of 2015?
I did.
And can you tell the jurors, as it relates to the mapping or the plotting that you did for Mr. Copeland's records, were they consistent at times with being near the Green store?
Yes.
Again, Your Honor, I'm going to object to
Cumulative, Agent Burney has already testified.
I'm gonna jump out the window, bro. Today has been pointless, and we're 2 hours and 16 minutes in.
My response is these questions will be brief, but again, Mr. Sprinkles' analysis is related to the statement that Mr. Copeland was impeached with during his testimony for the statement he gave on June 10th of 2015.
All right, and can you clarify whether whatever this analysis is based on Mr. Sprinkles' own plotting or whatever Mr. Burney had already done?
Yes.
His handset was consistent with was utilizing a tower that was consistent with it being at or in the area of the Green Store between 7:26 and 7:27 p.m.
Well, also, it could be at the scene of the crime, which the defense already got out in front of the jury, so I don't know what we're doing. The Green Store and the murder scene are very close.
Mr. Copeland's handset being in the area of Sky House Midtown.
It was later that evening. His handset, from what I recall, from what I remember, it was after 11 p.m. That was the location that was said to be where Mr. Copeland and others converged later that evening on January 10th, 2015.
Okay.
We've heard about everyone converging on Thug's condo for days and days.
He mentioned there was an Infinity that was involved, and they believed that the manager for Mr. Williams rented the Infinity.
Okay. And can you tell the jurors, after getting that information from the statement, did you request anything from any rental companies here in the city of Atlanta?
Yes.
And can you tell the jurors, did you receive any information back as it related to any rental vehicles in the name of Mr. Williams?
Your Honor, I'm going to object to asked and answered
We've heard this about the rental.
previously.
I don't know if it has been with this witness, but it's certainly been established.
I can move on.
All right.
Why are we looking at the f***ing rental again?
Can you tell the jurors what you're able to determine what type of vehicle that is?
2001 Pontiac Bonneville, gray in color.
And in conjunction with all the things that we described that you've reviewed, the statements, the call detail records, the video surveillance, I know you briefly spoke about it, but did you also review different social media accounts and photographs as it relates to some of the individuals, specifically here, Mr. Bradford, that we described previously?
Yes. Posed in photos with a 2001 Pontiac Bonneville. I mean, he'd be leaning up against it, et cetera. It looked like it was just a car that he was with frequently.
So here's Javaris Bradford, the Pontiac. Remember, they say the Pontiac drove by and the Infinity they were in tandem when the murder occurred and everything. I think they say Thug was in the Pontiac, right? Dude, this trial's so long I forget shit, like simple things like that, because all the chaos.
Pontiac, can you describe to the jurors where that's from? There's two photos contained within. How are they relevant to each other?
Well, the one on the right is a still shot from the surveillance footage from the night of the murder.
Okay.
From the Texaco station at 6:41 p.m. So it was there. The Pontiac was view of the surveillance cameras at the Texaco station when it pulled up into the pump at 6:41 p.m. and until it drove away from the station at 7:17 p.m. Yes, his phone traveled to the Texaco off of Cleveland Avenue after it departed the area.
So that's how he identified Yak, which we already know and have seen all this.
It was very shortly after the Pontiac Bonneville arrived on scene. If you would like the exact matter of fact, I just looked at my report to refresh my recollection about this. It was actually 6:42 p.m.
Okay. And here I thought the screenshots would be less difficult than the freezing video.
Objection, Your Honor. This is cumulative of prior testimony that we've had.
Yep, it sure is. I'm gonna throw myself out the window. What a waste of a day.
Any response?
I mean, there's been no.
Is this going to be a comparison?
Yes.
Okay, overruled.
Well, the 911 call was placed contemporaneously with the shooting, and that 911 call was placed at 7:22 p.m., so that call was 20 minutes after the night.
Object to speculation, unless there's a foundation.
On the what?
The contemporaneous.
Sustained.
I need clarity. I'm not certain it's the contemporaneous. I know what
I
it
don't
means.
know if he is able to testify from anything that it was contemporaneous with the murder. I think that's what the objection is to. Is that right? We can testify to what time the 911 call was.
Yeah, he can't say it was right when the murder was happening. Doesn't that word mean that? Like it's contemporaneous? Existing or occurring in the same period of time. Sprinkle in his ridiculous vocabulary, dude. I've had to sit through hours of it. I want to jump out the window, dude.
Because it was an Infinity Q50, 7:16 p.m.
Okay. And at the time that you reviewed the video surveillance, can you tell the jurors, did members from the Pontiac interact with the vehicle depicted in this state's exhibit?
Yes. The man that occupied the front passenger seat and then entered the store at 6:42 p.m. wearing the coat, he interacted with the person or persons occupying the Infinity.
Well, I guess can you explain to the jurors what you observed that person, I guess, do?
Objection, cumulative, best evidence.
Oh my god, this is rough. This is so rough.
Sustained.
About a minute, if that. It pulled in at 7:16 and pulled out at 7:17.
Your Honor,
Yes.
I'm going to object. Can I maybe approach?
You may.
Please, Max. Please get this over with.
Basically, the watches of the surveillance video and the cell phone records were synchronized.
Okay. Was there any activity as it relates to the handset associated with Mr. McMullins and the handset associated with Jeffrey Williams?
Your Honor, this is
Cumulative. Agent Burney already testified to all this.
Sustained.
Thank you, Judge. Please keep sustaining all these. Let's get this over with. Max Schardt cross on Sprinkle.
Start out by talking to you about the jail calls, and specifically my client, Shannon Stillwell's jail calls.
Okay.
That was from November 19, 2015, correct?
That's right.
All right. And November 19, 2015 is the day that Shannon Stillwell had his prelim, correct?
That's what I recall, yes.
Okay. And that's why you had interest in that call?
That's right.
All right. And that call was made later in the day after Mr. Stillwell would have returned back to the jail from his preliminary hearing?
That's right.
All right. Detective Thorpe testified in that preliminary hearing, correct?
Yes.
Okay. Kenneth Copeland did not testify?
No.
Demekion Garlington did not testify?
No.
Quindarius Zachary did not testify?
No.
Okay. I know it's hard to hear, but we're going to bring some volume to it, okay? Mr. Stillwell on that call said, I just went to court and they let everything out.
That sounds right, yes.
Okay, and that was, after Detective Thorpe testified, correct?
That's right, after he heard Detective Thorpe's testimony. Correct.
Okay, he said they threw out, and it was tough to hear, so I want to make sure we're clear. On that call, he said they threw out Yak, Duop, Nard, correct?
I don't recall that they threw out Yak.
I'm not suggesting throughout the case. I'm saying throughout the names.
That sounds right. I definitely heard him mention those names.
Okay.
So I took it to mean maybe like their names were mentioned, maybe?
Right. And because it was hard to hear, I was just trying to make it clear. He's not saying, nowhere in that call did he say he was with those people or anything like that day?
No.
Okay. Those names were mentioned by Detective Thorpe, correct?
That's right.
All right, cool. In that call, he said F word D, Woody, and the other D, correct?
I don't know. Yeah, that's not a verbatim quote. It's pretty close. I mean, I think the spirit of his comment was captured in your quotation there.
Okay, and then he said, them F N-words know what is going on.
Something along those lines, yeah.
And then...
So it's all about a call with Shannon Stillwell talking to someone after a hearing. The state is trying to say he's like mad at Lil D for snitching.
Tape that was played in court today, but there are 8 other calls on that CD, correct?
Correct.
You also listened in on another call that Mr. Stillwell had with that same young lady on November 23rd, 2015, correct?
I think so. That sounds right.
At 16:08, at 4:08 p.m.
That sounds correct.
All right. 5:07 into that call, Mr. Stillwell says, N-words will say whatever, correct?
That sounds correct. I know that was the general spirit. I don't know if that's an exact quotation as to what he said.
Okay. At 5:15 in that call, Mr. Stillwell said, they just trying to get the heat off their ass.
Again, that sounds like the general, that was something along the lines of what he said, that was the topic of conversation. I just can't say if that was a verbatim quote or not.
And again, Mr. Copeland at that time was facing federal and state charges.
That's right.
And Mr. Zachary, the other D, was facing charges related to the April 28th, 2015 shooting of houses, correct?
That's right.
All right. Mr. Stillwell in that November 23rd, 2015 call said, people will say anything to save their ass.
What's the best evidence? Mr. Schardt like to play the calls and
Sustained.
It is in evidence, trying to save some time, but...
I appreciate that, but if there's a valid objection, I've got to sustain it.
She sustained that, saying because he has to play the calls. What? He's trying to save some time.
911 call was made at 7:22, but we don't know how much time passed between the shooting and the 911 call, do we?
No, I can't say exactly. From what I recall, it's pretty quickly, but I can't say the exact seconds. The possibilities are endless as to what somebody could do before they call 911.
And some people will do certain things before they call the police to where they're at.
objection, circulation.
Sustained.
Well, the bottom line is we don't know how much time passed. So we're dealing with inexact times.
Yes.
Okay, great. The Green Store is within a minute drive of the barbershop?
It's pretty close. I don't know. I can't say if it's a minute, but it's less than a mile away.
Less than a mile away. Thank you. Javaris Bradford has come up, a.k.a. Tudor, right?
Yes.
Okay, he's the owner of, through your investigator, he's the owner of the Pontiac at the Texaco.
Yeah, from what I recall, he was the registered owner.
Right, and he came up in your investigation, and the fact that Pontiac was on the video piqued your interest.
That's what I said, yep.
All right. He wasn't charged in 2015.
He wasn't.
Okay. In November of 2018, he was still in the community, correct? He wasn't in jail or anything.
That's right.
All right. And you determined that you wanted to speak to him.
I did.
All right. And did you reach out to him?
I don't think I reached out to him. It was likely a DA's office investigator. Somebody reached out to him.
Okay. And was he asked to come in? Was he compelled to come into the DA's office? How did that work?
I believe we gave him a grand jury subpoena, if I remember correctly.
Okay. You issued a grand jury subpoena for him to come in, and you had a meeting with him in a conference room in the DA's office, correct?
Right. It was on video. I have it right here, actually.
Yes. And Javaris Bradford showed up, correct?
That's correct.
He did not have an attorney.
He did not.
No, he went there without an attorney?
You told him that there was evidence against him in this case.
I don't recall exactly what I said. I likely said that to him. I would go so far as to say as yes, I did. That would
report. I'm sorry for interrupting. That your supervisor wanted to charge him, but you were holding things off to give him a chance to talk.
Yeah, I mean, it is. Sustained.
Okay.
What? All right, Doug Weinstein up for Yak ID Croft.
I don't see Mr. Kendrick's phone on there.
That is correct.
So you didn't do any analysis for Mr. Kendrick's phone on January the 10th, 2015.
I was without records to analyze for Mr. Kendrick's phone.
Okay, so you have no records of his phone on that date, correct?
Correct, yes.
Okay, thank you.
Oh man, Doug Cookin. We all pointed that out yesterday, that Yak ID was clearly missing, and so was Shannon Stillwell. Brian's still up for cross.
If that surveillance at the McDonald's captured people actually meeting, then we would know who was actually there and if Mr. Copeland was being straightforward. Is that fair to say?
Object to speculation.
Sustained.
Did Detective Thorpe ever tell you, besides his file, did he tell you that he went out and looked at and saw or tried to see the video from the 10th day of January 2015, approximately 8 o'clock p.m. from the McDonald's?
Objection, here's that.
I covered this with Detective Thorpe, and I'm impeaching him.
Overruled.
I don't recall him telling me that. It doesn't mean that he didn't, but I just don't recall it. It just seems like something that would leave a mental impression on me because, again, I would have just thought, well, where's the video? I don't have the video. I would have liked to know that. So I don't think he ever did.
In your
Lying ass mother.
experience since, I believe you said 2012, but it might have been 2009, with the DA's office in Fulton County, have you looked at and subpoenaed, whether or a grand jury, or excuse me, a court search warrant, a surveillance video from stores?
I have, yeah.
Have you found that after a certain period of time, some of the video is erased or
So still just trying to point out that Thorpe lied about the surveillance footage, pretty much.
deleted?
Yes, that's the practice. The videos are all digital. I don't want to say they're all digital. There may still be people using tapes, but every video I've ever seen has been digital, and they only have so much room on the computer system that's storing the video, and eventually...
Have you seen a surveillance video that lasts 30 days?
I believe so. Yeah, I don't want to throw out any names, but there's one place in particular that comes to mind, but it's not relevant here, and I also don't remember exactly, but I do believe that 30 days I have seen before.
Okay. What's a typical days that until it starts overriding?
I'm going to ask and answer speculation element relates to McDonald's video.
I'm impeaching Detective Thorpe.
Still out for blood today.
Your typical, like a gas station, particularly in 2015, where it was stored within, probably on a DVR, you're going to want to get that as soon as possible. You can start overriding after 48 hours.
Does the entirety of everything in those 2 weeks go away, or is it on a rolling basis?
I'm going to object to ask and answer on
Not of this witness.
and speculation as to this witness.
He's asking within his experience. Overruled.
Are we talking about one location and one, if we're talking about surveillance footage, one location and one computer system, we're talking about the entire world of surveillance footage?
McDonald's, 2015, January 10th, surveillance, just typical McDonald's, your experience, hypothetically 2 weeks. I want to know on the 15th day, so I'm just after the 2 weeks, would you explain to the jury, does day 1, January 1 override, or the entirety from January 1 to 2014? That's my question.
To lack of foundation at this point.
Sustained.
Does it override just one day at a time? As the next day comes in, the first day's gone.
Vague as to your experience to a camera in a 2-week period. Any camera? I mean,
Sustained.
When you say override, tell the jurors what you meant by that.
asked and answered.
Sustained.
I don't believe he just
Yeah, he
used the
did.
word.
He explained it in detail.
All right. Did you ever find out that McDonald's, how long, if at all, they had that surveillance video?
The record retention period for surveillance video, if I knew it, I don't remember it now.
So now you don't remember something, Sprinkle. You remember everything the state asked you. Just be yapping away for minutes on end.
Conversations that Detective Gaither and or Detective Dennis went to the McDonald's on the day after interviewing Kenneth Copeland, June 11, 2015, and inquired about their surveillance equipment.
No, I have no notes that indicate that. I have no memory of any conversations that I had with them where they told me that they did.
Sky House, you know the condominium that Mr. Williams was living at in January 2015?
Yes.
Okay. Any surveillance from there?
No.
How about the Green Store? Any surveillance at the Green Store that Kenneth Copeland states that he was there, personally there, at and around the time of the killing of Donovan Thomas? Any surveillance from there?
No, no surveillance.
On January 11, 2015, explained to Detective Thorpe that he was aware that check the cell phone records, check the cell phone, it'll show it's in this area. Do you remember him saying that?
I remember somebody saying that during the, I can't say that I remember if it was him, though.
All right. Copeland stated on June 10, 2015, from the McDonald's, that he was in his car at some point, along with Mr. Garlington and along with Mr. McMullen, Demise McMullen's, also known as Nard.
If I remember correctly, I think he said it was his brother Rontrez Brock's Dodge Charger, but yes, all three of them were at the McDonald's in that car. A car that he had possession of. Kenneth Copeland did, that is.
Okay. And Kenneth Copeland said that I'm not saying it's true, but Kenneth Copeland said on June 10, 2015, he left the McDonald's. I'm using 8 o'clock. If I'm wrong, just correct my time, but approximately 8 o'clock. He was driving the vehicle, the Charger, along with Mr. Garlington in the front passenger seat and Mr. McMullen or Nard in the rear driver's seat.
That sounds right, yeah. I don't recall what the exact seating arrangement was, but the occupants of the vehicle, that sounds correct.
And then he has that car, the Charger, going up, following another vehicle, a Nitro, white Nitro, to around Jeffrey Williams' Sky House condo.
That's what he said.
Did you look, when analyzing the calls from Naisha Williams, records rather, from Naisha Williams, and realize that during that relevant period of time, on the supposed drive from McDonald's to the Sky House, the Naisha Williams call that's potentially with Mr. Garlington and the Mr. McMullen calls, the number associated with Mr. McMullen, were in communication with each other?
Are you asking me, did Mr. McMullen and Ms. phone subscribed to by somebody named Nyesha Williams communicate?
Is that the relevant time of when supposedly Mr. Copeland is driving them together in the same car to the Sky House? Yes, that's my question.
I don't recall. I do recall Mr. McMullen was a very frequently contacted number within the Nyesha Williams phone records. But I don't have.
Do you remember Mr. Copeland stating that Mr. Treadwell had, or O.G. Bentley, also known as O.G. Bentley, had guns that were used in the shooting of Donovan Thomas and the other 2 people in his car given to him around the McDonald's 2010 that we talked about?
Yes, he said that.
Do you have any physical evidence, surveillance evidence, anything to corroborate that those guns were actually in that car at any time or given to Mr. Treadwell?
No.
Ever tracked the cell phone associated with Kelvin Watts, also known as, do you remember his?
I do remember. I know Kelvin Watts.
Shell, same person?
Yeah, I know who he is.
Okay. Tracking his cell phone historic data related to these shootings in 2015.
Well, for Mr. Watts, the one case that I recall was a shooting of a fatal shooting of a young lady named Tiara Jones. We did have phone tower logs, and that would have been September 2015, but that's the only case I remember.
Did you or your coworkers, the prosecution team, ever analyze the cell phone historic data records for Kenneth Copeland's phone from these shootings in 2014 through 2015?
Well, apart from what we're talking about right here, January 10, 2015, I don't recall now.
All right. Then, at some point, do you remember the date in 2018 you interviewed Mr. Kelvin Treadwell, O.G. Bentley? Do you remember that?
Which day was this again?
2018.
Oh, right. Yes, I do remember that. Yes, that was another matter, but I do remember it.
And do you remember stating that you can't understand why people think that Thug, I call him Jeffrey, had something to do with the killing of Nut, I call him Mr. Thomas? That doesn't make sense? That's a thing that always confused me about this case, because all these rumors started immediately that Young Thug had something to do with it. But yeah, then Young Thug put a picture of him on Instagram, Mr. Thomas. So I'm looking at these people saying, oh, you and Little Woody had something to do with it. The more I've investigated the case, I just don't, near as I could tell, Young Thug and Birdman were friends with Mr. Thomas or Nut. So I don't know why people say that he was involved.
Well, I recorded the interview, so I'm assuming that's a verbatim quote. I don't have everything I said during that interview memorized, but I'm assuming that, like I said, since you're reading from a transcript, that, yeah, I said that.
Oh my god, dude, this guy. I hate Sprinkles so much, bro. So here's a gang expert. Apparently could be the replacement to Dennis, because Dennis fucked himself.
And as a federal task force officer, did you find that you were involved with more of the YSL side of the gang war or the YFN side of the gang war?
Sustained.
Okay. What were the 2 entities that were engaged in this gang war?
Objection to characterization.
Answer cumulative.
Sustained.
In your opinion, was there a gang war going on in the city of Atlanta?
I'm clearly going to object to cumulative 704B, and this is the fourth gang expert that the state has called the same exact event.
Yep, please sustain it, please.
One of them was all of yesterday's testimony from that person was excluded. So
I didn't mean to interrupt the honorable court. Actually, that person testified 3 previous times.
I know, and that was not excluded. And I would imagine. Why don't y'all approach?
What? It's the state's fault for all this. Their replacement doesn't get to go over what Dennis, bro.
After the shooting of Donovan Thomas, was there a main target of individuals associated with YFN or If gang?
I don't understand the question.
Sure, sorry. Did they have someone that they were targeting, individuals who were associated with If gang and YFN after Donovan Thomas's murder?
Vague with they and also.
Sustained.
Sure. After Donovan Thomas's murder, was there an individual who was targeted?
Yes.
God bless you.
Speculation calls for speculation of the intent of others.
Sustained. You may rephrase.
Sure. Based on
Rayshawn Bennett, aka Lucci's mother's home being shot over on Hill Street in Zone 3.
I'm going to object to previous testimony already given.
Yep. Don't know what we're doing.
It's cumulative.
Okay, go ahead and get to whatever point.
I'm going to ask her about the first time. Were there individuals from YFN who were at the location when police? Because that's going to form what I have to ask next.
Same objection.
Yeah, this is part of what occurred yesterday.
Go ahead. I'll give you some latitude.
Thank you.
Wait, so the judge is just gonna let them replace their lead detective with someone else? A little f***er they sit in the seat, another new f***er? It's their L. They shouldn't be allowed to replace shit. This is fucking annoying. Alright, Mounk Tounk's whole probation situation. Here we go.
What you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, Defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42, and I point out specific issues with the draft that need to be revised.
Right.
Now,
Yeah, and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor.
Remember, this whole situation is about his factual acknowledgments. When he was agreeing to this in 2022, there was a miscommunication with his lawyer that's sitting next to him. That's why there's emails and shit.
These revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim, and therefore number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is.
I'm not sure about that. That may be your contention. But
well, we would contend to the court that where.
You think Miss Love knew or not? It wouldn't surprise me, but might be a little bit of a reach. But either way, he signed this plea, right? He signed it. So on the stand, he basically has to get down on his knees and suck this plea's dick. That's the way I see it. If I was him, I'd be singing. I have to say exactly what's on that plea, or else he's right back in this situation right here, and he's going to get put back in prison.
My actual email, Defendants 2, clearly denoted that.
It does not. It is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So,
but your response on your Defendant's Exhibit 2 to what is then item number 4 does not definitively state anything like what you just said. Okay. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
you maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is.
Kind of sounds like it's mainly his lawyer's fault, because I'm sure Mounk Tounk doesn't know how any of this shit works. He's just trying to get out of jail.
You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the...
Oh boy. Pages, she about to put this man in jail.
Sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And
this isn't sounding good, boys.
Sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, I think the court can take note that he literally shut down, and some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated.
This is not going to go well. Oh man, what a disaster. This is actually an embarrassment for Fulton County. This whole thing. So he's going over his criminal history. Oh, man.
A obstruction of law enforcement officer, which was a misdemeanor. That was May 19, 2005. I'm sorry. He used his first offender. The second case, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
Full candor to the court, Your Honor. I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
God, what a disaster. He used to go back to prison.
I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the request.
You're just telling me that's what he has at this point, although it can't be.
No way, 30 years. There's no way they would do that. 30 years probation, by the way, is a trap. Someone like Mounk Tounk, who has a pass and his boys and everything, that's a trap. Like, he's going to get caught up in something.
I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble.
God, his lawyer's doing one last Hail Mary.
He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence.
View it as a technical violation or akin to a technical violation, considering that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you...
He's going to have to go for 5 years. Wow. He doesn't have to do the full 5 years, though. It'll probably be like 60%, right? Or 70%?
Have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I'm fine there to have been that violation. I'm revoking 5 years.
Honestly, this is majority his lawyer's fault.
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
This is f***ed, man. He was changing his life, working and shit. I would have gotten on my knees and sucked that plea's dick straight up. I already got the plea, I'm out. He was able to explain himself for the factual acknowledgments, but he straight up said a lot of it wasn't true, violating his plea. I feel bad for him and his family and friends, but fuck, man, that was rough. Hit subscribe to the membership. Love you guys. Peace out.